Hello, I'm Stephen Gold, before a haircut, the author of The Return of Breaking Law, the book What I Wrote, and here's the very latest in LAWLAND. You need legal help. There's no legal aid available and you can't afford lawyers' fees. In my book, I provide a series of organisations you can contact who may be able to give you free expert assistance. One is called Advocate. A barrister, free of charge, could advise, draft documents, help with mediation, and represent you in court or in a tribunal for a specific part of your case. That could include the main hearing. I warned in my book not to contact Advocate directly or they might biff you, but that you had to go to them through an advice agency. No longer the case. Coronavirus change means that direct contact can now be made.
Is there a phone number?
You can afford a lawyer. For anyone deserving who cannot, try 020 7092 3960. 020 7092 3960. Divorce, something the whole family cannot enjoy. You thought the divorce laws were getting easier. No more blame for nose-picking, adultery and bad language. Well, you were right. The changes have not yet been brought into force. My current information is that the new laws are on track to be up and running on the 6th of April next year, 2022, and procedural rules should be published next month in January. You'll be able to bring proceedings in person without a lawyer under the new laws as now, be they for divorce, civil partnership dissolution, nullity or separation, and divorce cases will be possible online. Cases will be near impossible to defend though. The real battleground will be over division of the finances. Ouch! Nothing different there. Since the pandemic set in and the finances of so many people have taken a plunge, there have been various attempts by husbands and wives to overturn court orders dealing with the family finances on the ground that if they had to comply with them, it would be manifestly unfair. The orders, they say, didn't take the consequences of the pandemic into account. Nobody told them it was coming or how badly it would affect them. By and large, judges have been sympathetic but unwilling to cancel the orders. In the latest case, just a few weeks back, Mr. Justice Mostyn declared that COVID probably was not an event which justified an order being cancelled, but that it depended on the specific facts of the case. Hedging his bets there. In a previous case, another judge thought that COVID could justify a cancellation, but not there, as the husband who was after cancellation had agreed to the order only 9 days before we went into the first lockdown. He should have foreseen what might happen, declared the judge.
So, one side may have to pay over money they haven't got, even though that was down to a dreadful disease?
Calm down. If cancellation cannot be achieved, it may still be possible for an aggrieved party to seek a reduction in maintenance payments or more time to pay instalments under an order for a capital sum. And now for something completely different. Service charges.
But you did that the other week.
Oh, give me strength. This is about those charges which landlords inflict on tenants of flats, sometimes houses as well, for repairs, cutting the grass, buying the porter a high visibility top. You lapped up my video on that in the millions.
Millions?
Well, hundreds of thousands.
Hundreds of thousands?
Oh, hundreds.
Hundreds?
All right, I watched, and my partner, and you. And what's happened since is that there's been an important judgment from the Court of Appeal, which is good news for tenants in two respects. Remember, the case depended on the exact wording of the lease in question. But that wording was the same as, or similar to, the wording to be found in millions of other leases.
Millions?
Oh, shut up. Yes, millions of other leases, especially older leases. The first issue on which the tenant won was over the lateness of the landlord's demand for payment of what was an interim service charge. The question was, did the lateness matter? The Court of Appeal ruled that usually lateness would not be fatal to the landlord. That would be presumed to be so. But here, the express wording of the lease displaced the presumption, and it would be more likely that a late demand would be ineffective where interim rather than final service charges were involved. The tenant needed time to do their budgeting. The second issue was this. In tribunal proceedings between landlord and tenant, the landlord had run up a big lawyer's bill. It sought to add the bill to a service charge so that our tenant and all her co-tenants would have to fork out for them. But the lease wording didn't say anything about such bills being added on. These were litigation expenses, and the focus of the lease wording about what the tenant would have to pay as part of the service charge was on management services and not on litigation. Tenants rejoice. Well, some do. Bad news if you have a court judgment against you and your creditor has put in an enforcement agent. That's the High Court's version of a bailiff and is generally for the larger debts, certainly anything over £600, usually much higher. Well, the more the enforcement agent has to do to extract the debt from you, the more the agent charges, and those charges are your responsibility. They're laid down by regulations. The work the agent does will be subject to VAT. If the creditor isn't registered for VAT, the creditor can't get back the VAT wrapped up in those charges from Revenue and Customs. So then, who is to bear liability for that VAT? The creditor or you, the debtor? Well, you guessed it, you, the debtor. Regulations which came into force this month on the 9th of December 2021 say so. That's your lot. Goodbye.